It is dated July 30, 2026, and this is a full board staff meeting. First order of business is to review our agenda. Any suggested additions or deletions?
I would like to add after the minutes, it's totally slipped my mind that Cassie and Dave are coming, and again, I apologize. I'd like to add them to the agenda, just of any DOT Q&A or topics, and a couple of things that we've got coming up in the next couple of weeks.
Great. So we'll put that in as 2A.
Yep.
Anything else? Motion to approve the agenda as amended would be in order.
I'll make a motion we amend the agenda as noted. Sorry.
Motion's made and seconded to approve the amended agenda for today. All those in favor signify by saying aye.
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 Tom, are you there? Yep, he's got his hand up. Thanks.
Yeah.
Yeah.
Hand at work.
Yeah, minutes from our June meeting. We'll have a chance to review those. Motion for their acceptance would be in order.
I'll make a motion that we accept the minutes as printed.
Again.
Motion's made and seconded to accept and approve the minutes from June 2026. Any corrections or changes from anyone? Hearing none, all those in favor signify by saying aye. Aye.
Aye.
Thank you. We can move on to 2A, which is our yes from DOC. See you. Morning, folks.
Good morning.
Morning.
And again, I apologize. I swear I'm scattered all over the place lately.
Oh,
No worries.
Is there anything specific, any specific topics that the two of you would want to address the board with?
I didn't have anything, but just to let I say that and then I launch, right? I do that all the time, so I have to stop that. But mostly just a friendly reminder that MJ is coming to our LUS supervisor crossover meeting to discuss any kind of things that are coming up, hiccups along the way. I know that we've received feedback from staff pertaining to the process in which violations are occurring. Meaning that, because they don't have attorneys and how that cross-examination is happening with POR, that it's not there, that there is some confusion. And I know we're still working through that process and how that looks. So that's one of the things that we're hoping to continue to work on, supporting our probation officers with. The other thing we understand is that there's presentations of advocates coming in saying they've built reentry plans. I don't know if the board has any questions or if we can offer any guidance around that, kind of like what we did with VMRP. So that would be two. I don't know if Dave, did you have anything else?
I think those were the big topics that we've been hearing since the last time we met.
So I will say, Cassie, we do have Valerie Viveros Venuto from the Northeast Kingdom Community Action, who does the restorative justice program up at Northern State, going to give us an overview of their program later today, just so we have an idea of what is going on. I did talk to Randy a little bit about that, and he said that's more in Derek's shop. So
which I've been following up on. It hit my radar. So I actually got to meet with the transitional housing and the CJC, not even last week, or maybe it was earlier this week. I feel like they're all merging. So I'd love to hear her presentation, and we're just trying to navigate what that really means when they build these reentry plans that are not necessarily vetted or supported by Department of Corrections. And what that looks like. If the Department of Corrections is giving and saying they're not recommended, you know what I mean? It puts really weird pressure on the probation officer and the CSS if they've given guidance about not recommending, and then these plans are built. So I guess that becomes the determination of the board if they feel that it addresses those risks.
So where it really comes into play for us, Cassidy, and
Yes,
we've
sir.
only seen it one time now, is in our domain where we talk about programming. And in many cases, there's none that's been offered or none scheduled for them until, or if they get released in some cases. So this is the first time where someone has come in from outside DOC and presented us with an overview of the program they conducted at the facility and what was talked about, what was done, how the person did, and that sort of thing. So it kind of falls into play when we rate the category of programming, but we're not sure where it came from either. I mean, did DOC invite them to participate? And are they looking at just folks who don't do programming that's DOC prescribed? Or how is that being
So
facilitated?
basically, I can give you what I know, and I actually have a document that explains each program because Northern isn't the only facility that has
Oh.
it.
Oh,
So
okay.
CJCs throughout Department of Corrections were given a grant to do a restorative justice, which could mean circles of accountability within the facilities. Some of the curriculum is really cool. Northeast Kingdom NECC just graduated their first class. And these are volunteer programs. So they're not something that DOC says you have to do. So I think there is a little bit of weight with somebody who's agreeing to sign up and utilize their time in a pro-social manner. Where we're hung up, DOC is hung up, is the reentry piece to it and the coordination and ensuring that if they're building this reentry plan, it also has eyes on it, both by the CSS and the PPO, and how that looks to help. And that's where we haven't gotten there. I'm going to send an email to Chris Barton, who I'm going to ask if I can share this report of what each program are being done in each field with you. If I can share that, I will forward that to MJ this morning. I found it interesting because it talks a little bit about what each CJC is doing that's grant funded in the facilities to support the restorative justice, which I'm all about. You know, I'm behind the restorative justice piece and the accountability piece. Where it gets conflicting is with these definitely RSN risk containment case is if we're saying no, you know, that's going to leave it looking like to the board that we're not working collaboratively, but that's the direction, and that they are able to choose to participate in this and they can build it, but that's not necessarily mean DOC supports that individual plan. We support the program and what's being done, but we can't support that individual plan. Does that make sense, or am I kind of talking in circles?
Well, I have a quick question. Does that mean DOC may not even be aware of the plan either, that they may be building this plan in the restorative justice program, but it's never been presented to a caseworker or a PO as well?
Right. That definitely, of course, that could be one of the
Interesting.
issues that comes up.
I just wanted to that caught me, and I wanted to just flag it a little
Well, what's
bit.
important for us is if the program is addressing their risk areas, which in this one case we had, it certainly looked like it was predominantly. Is DOC on board with how that's progressing? I know that's separate from the release planning, but it's an important piece of the programming and accountability and moving on from that component, really where they're not getting anything otherwise. And if they volunteer for this program, and then the overview is given to us and their participation is evaluated, it certainly counts for something in our programming.
Sure.
Category.
And that's at the discretion of the parole board. I think where it comes down to is what is that, if they're giving that information, they've built this release plan, but have no identified housing. You know what I mean? Like there's a difference between participating in restorative justice practices and for me, a release plan. So what has
I agree. I'm not trying to suggest
Yeah.
it doesn't, Cassidy. Sorry.
Yeah.
It's just that from the programming component, if that program is addressing their risk areas, whatever they happen to be, then release planning is totally different. That's another category. Where are we at that? What's DOC's recommendation? Sometimes, in a lot of cases, whether they're risk contained or not has not been determined. And sometimes we'll just get information that, well, supposedly it's in the works. Well, we can't evaluate what's in the works. We can evaluate what information we're getting at this hearing. and have to make a decision, particularly if it's a minimum.
Yeah.
At that time.
Yeah. It's kind of like a system that we just keep missing each other and pulling in things.
Yeah.
And so we're sussing it out.
Yeah.
What I will say is that based on some of this information about release planning, the department is committed. We have a meeting scheduled in the second week of August to let you know, to talk about what we actually are looking for in a release plan, and trying to make something that's universal versus individual per facility. And mind you, that might take some time, but I do want you to know that this is about transparency of things coming down the pipe.
Yeah.
And, creating this relationship with the parole board is that it is on our radar. We are working and looking at it so that people aren't feel that they're being pitted or thrown under the bus.
Yeah.
I don't know how to say it any differently. So that's kind of where we're at with that. So that's like an overview. We're addressing it, we're looking at it, but also, do you have any other questions around the release stuff? It's hard.
Anyone? Anytime. Tom?
No, not at this time.
Well, I have a lot of issues with release stuff because I don't think it's transparent enough, and I don't think the caseworker, the POs understand it either. When somebody's RSN or whatever, and they say that well, they have a place to live and all this thing set up, but we still want 6 months or a year of behavior. And I said, well, if he hasn't had any issues with behavior, what's a year from now going to be? So I still have some issues with how the transparency is regarding release plans and how that works out, and it just it doesn't seem that everybody's on board, even with the POs and the caseworkers. If you ask them, they'll say, "Oh, central office made that decision."
And it ultimately is our decision. You know
Yes,
what
it
I
is.
mean? Like,
I got it.
Based on, and one of some of the criteria we look at, in which we're getting, I think, because this was happened a year and a half ago, we like doubled the RSN. So, in this process, we're really understanding and looking at these cases that are RSN, the impacts of, have they mitigated their risk, and do they continue to do the same thing? So when we're looking at specific cases where it's the same plan that we did 3 times, where it resulted in a technical violation and increased their incarcerated time, we're asking for accountability and what's going to be different. We have that conversation weekly with the case staffing the committee, and pushing that out. What's going to be different? Because we are looking at those case plans, and I can understand, and there is frustration. I acknowledge that the CSSs and PPOs may feel. So we're offering more case conferences before they come to the committee to help support building those, and how to articulate, and what may what has to happen for an RSN release.
But that's perfect. What you should be interrupted. Exactly what you said, though. You said, "Oh yes, well, the reason he's RSN is because he had the same behaviors 3 times," and that I can accept, but not just say arbitrarily he's RSN and that's what we got.
And I'm not sure who's articulating that he's RSN and that's what we got. I mean, I'm saying this. He's RSN, and I'm looking and say, wait, why is he RSN? Without, if a PO caseworker describe what you just said, I can accept that. Okay. Yeah. So
what? Can I just interrupt and expand a little bit? So I think from watching these hearings, what's happening a lot, we're seeing a lot more, again, a reversion back a little bit to the caseworker and POs not agreeing as well. And we get a lot of caseworkers who sometimes are going against the case staffing sometimes, of that they're the ones saying, well, we had this plan, we had it great, then central office said, no, I'm not sure, I don't understand why they can't go out. And then the PO will come in and give a more detailed reasoning. So we're getting we're going back a little bit of that back and forth between the PO, the field, and the facility again. And so I think, I just wanted to clear, that's where I think some of it's coming in, and that might be a conversation that we have at some point too.
It sounds like a great conversation for 8-6 when we have our supervisors and our LUSs there and remind, and we can bring forth, we have that, I like to call it my keeping list that I'm going to give to Dave of things that we talk about, remembering we are on the same page.
Yes.
And it's unfortunate that that sends mixed messages, but we also are going to have that one-off
Right.
in cases
Of course.
repeatedly. We're looking, I mean, the parole board, but also us are looking at hundreds of cases a year. And of course, it's going to be always that one case that you're like, well, you know, so it's just something, an ongoing conversation. Dave can address that at our crossover meeting.
And something else just to throw out there, Cassie,
Yes,
and just
please.
for future, is I think sometimes it may not be clear where the executive committee how the executive committee came to their decision to not accept the release plan. And we've had that conversation with Lori a few times as well. I think that's some of it of, we know it's in the case staffing decision, but were they privy to more information than the board is getting to come to that decision? Are we not getting the full picture? And so that might be some future conversations to have too.
And I think if we want to go through another point where maybe I can offer some clarity, which I know kind of reflects my own process, is I look at the criteria for RSN, the A through G, and if I can fit it in just based on things like the record check, it shows the ongoing continued that evidence that he will be doing this again when they haven't come off for supervision for 17 years. And it's the same charges. So there's my evidence that he'll commit this further crime. The case staffing should always have so I can walk through if next time we can do that. Like this is kind of like what the criteria we see. So if someone gets an A, B, C, E, F, you know what I mean? Like I can tell you and kind of give you some tidbits that I consider as part of the committee member, and Dave can join me in that, of what we look for from that case staffing report.
So one thing to add to that, Cassidy, too, which we have found, and I continue to urge all my colleagues to read those case staffing reports. There's a great deal of information in there that's not in our parole summaries. And I wonder sometimes if the caseworkers have not reviewed the case staffing reports, because a lot of the reasons for the decisions are included in that report. And I think if they had that, they might present a little differently than I worked on a release plan. I'm not sure why it's not being approved. Kind of thing.
Yeah, and I think too, we often find ourselves back into, and you guys remember the old school, they're doing nothing but getting them out, and we're doing everything to get them. So we're still working on that standard day old fight. I think like it's the historical, they have to get them out, we're getting them in. So, you know, we're going to work out those kinks. Maybe, I don't know if it's going to be in my career, but maybe it'll be in the next person's management career. But I think that, thank you for that feedback. We do work hard. In our case staffings, I will say we're getting good feedback from the courts about them as well, with the more detail and recommend. And I'm glad they're included in your parole packet. But those are really what we lean into on the basis of those RSN decisions. And if it's not articulated, we often say, sorry, we can't see it. We did it a couple times this last week. So
good.
Thank you. Good discussion. I appreciate this. This is like good dialogue.
And also one thing just to let everyone know, along with going to the supervisors and LUS meeting next week, the week after, I've also been invited to this senior PO, the senior POs meeting, I think, to also talk to them as well.
Yeah, we're really trying to break down some communication, more transparency, Tom, with definitely, you know, ongoing work of getting people on the same page. But as you guys are probably experienced in your own careers, it's like, it's my magic wand in Oz that I live in. So glorious.
So on the violation piece, just before we leave that, or leave you guys quickly, you know, we're kind of adapting on the fly on this as well. It's in the cases where we have decided that we do need to have a witness because it's being challenged, the evidence in that particular part of it. The witness is essentially our witness because we're the ones subpoena that person in. But we certainly allow the PO to ask questions if they choose to, but we're not expecting that they necessarily have to. That it's sort of up to us to make sure that whatever information this witness is going to provide, that we get them to provide that if they can. And the defense attorney obviously will challenge that if they have any concerns about it. And we always give the PO the opportunity to, but we understand it's not their witness now. But certainly if they have questions about the content of what's being presented, we want to hear from them.
Can I jump to
And-
number 5 as you broach this topic?
Oh, sure.
While Kathy and Dave are here.
Yeah.
So we are moving forward with obtaining conflict counsel for the board through Act 111 of this session. We are, myself and I think Lori Fisher and Sarah London from the Attorney General's office are gonna be answering any questions that we have two council members interested in the position. The reason why I brought Lori in is because she's held the position. She's been our attorney before.
Mhm.
And Rob Lees is on paternity leave at the moment. But during that, our goal is to rewrite, is to get all this clarity around what the violation process is going to be, really draft it so we all have a clear violation process of what each entities are going to be.
Yeah.
So I just wanted to, we are moving forward. So I'm hoping by fall, we will have some conflict counsel who will be able to start that work and start providing training to the board and move forward.
And excellently, and we continue to work with the probation officers on understanding their roles and responsibilities. I would probably not encourage them to ask questions of a witness. They're not attorneys. And I would be concerned about that, to be honest and forefront.
Yeah.
I think sticking to their recommendations and the information that they provide in the affidavit is their role in this. But I know there's frustrations, especially when they feel very challenged by pro. And I wouldn't be field operations manager if I did just make it awkward and put it on the table. And that's where that give and take comes from. So though I would really, that's exciting news, MJ. Let us know how we can help support any of that writing or review.
And I'm sure it's going to be a collaborative process to a degree.
Yeah.
With all parties.
Yeah. So, but that's all I have.
I think that covered quite a bit, so.
Yeah.
Yeah.
Well, thank you both for stopping in.
Yep. I'm going to follow up on that form with Chris Barton to see if I can share it with the parole board. I think that might be helpful to see what's happening.
And
And
Kathy,
then
if you want to join at 1 when Valerie comes, or I can send you the audio afterwards if you want to review just what she offered to the board, I can send that to you as well, whatever works best for you.
I would love the audio. I have 3 meetings booked at 1.
Of
So I don't know how
I
I'm going to do that, but just today, not anything tomorrow. So I'll happily listen to it tomorrow. Thank you,
Yeah, of
MJ. I
course.
appreciate that.
Yeah.
Thank you to the board for
Great.
your time always and having us.
Yeah, thank
I
you.
appreciate the
Yeah.
opportunity.
Yeah. Take care, guys.
Thanks. Bye.
Okay.
I just figured that was a good segue.
Yeah.
Right, because you were talking about
Yeah.
that, but we can talk about it more. at the
You want
end.
to finish up with that before we move?
I mean, I don't really have a lot more to talk about other than we have 2 attorneys who are interested in the RFP. Sarah London has talked with them. I answered, I provided basic information, to Sarah to give to them. They're both local attorneys. They work with many different boards. I don't have my notes with me
Okay.
on me. Maybe I do somewhere, but they both work with other boards, very good candidates.
Do you?
I haven't met them yet. I'm
Yeah,
sure that
I don't know
well.
what their role is going to end up being, but whether they would be observing some of the violation hearings where we might expect there be.
They may. I think that's something we're going to determine when they come on. I think the ultimate goal is for them not to be at hearings, but probably they will want to observe them to see how they happen.
Right.
But I think ultimately their goal is to provide the board with evidence training, with the training of confrontation. I really want to go through the violation part of our manual and draft how our violations should be submitted, how our PC, when should we do PC, when should we not do PC, update the whole thing. Is the board the judge? Is it kind of the judge and the prosecutor? What is the board's role during these violation hearings? And that's what I want my goal to develop with this attorney, because we can have these conversations with the attorney without having PRO present.
Right.
Do either of them have criminal experience?
Yeah, I think one of them is the attorney for the Criminal Justice Training Council right now. And I think they do have some criminal, I don't know if both of them.
Necessarily mean it's criminal experience.
Them does have criminal experience. I don't know if both of them do, but that is definitely something to look at. Thank you, Wayne, for pointing that out.
Well, for the most part, since this change has occurred, we're kind of left with being the prosecutor and the
right.
judge.
Preservation is if you've been up with somebody with just pure civil. You're gonna go through 6 months of him training and stuff.
Yeah.
Yeah.
Cause he's fishing a whole different pond.
Well, into that, and I might be able to do it if I can find my notes as we're at lunch. Might be able to give you more of a background on who they are. I just don't have it down to memory yet.
Glad it's coming together.
It is coming together. Sarah London has been great. She has been putting this all together. She's got a draft contract already put together. They looped AHS Central Office contracting in yesterday. Coming together. I got to report back by November, so it's gotta come together. It does.
After the election or before?
Well, I think it's November. It might be it's either November 1st or November 15th. Our reports due to Senate institutions and House corrections and institutions. Whoever's on those committees.
Right.
And I don't mean to have my back to you, but you can't see me half the time anyway.
Any other questions on the conflict council? Good. Let's drop back and do our early release review.
So I will apologize. I wanted to get these through. One of these individuals, Patrick Boswick, keeps calling me. So I thought maybe we could I don't have input from DOC. They're kind of staying neutral on, because they're sex offenders.
Right.
So they're kind of staying neutral. It's Tom and Katie, these are in the July PD folder. We put all the staff meeting stuff in there this morning.
Yep, I'm seeing it in there right now.
And I can look up any information that you want to know about his, I'm gonna open up his profile now and I'll open up
Okay.
the offender management system too.
It's like
And just give you I'll let you read the letter while I pull up documents.
you had put it on. You had put it on the agenda anyway, so I've already read it.
I didn't put it on the agenda
I
until
read it.
I didn't put it in the folder until this morning.
I read it this morning.
Oh.
I was gonna say, I've got it up on my computer.
I was gonna say, I didn't even,
Teacher's pet, you know?
it wasn't on the agenda as of yesterday, so.
No, but I read it
I-
this morning.
Well, that makes me feel good because I was looking at this.
No, I put it
Yeah.
in there literally at like between 8 and 9 o'clock this morning.
Good, I feel better now.
And I did start working at like 6 this morning, but yeah, no, it wasn't.
Yeah, I read it.
Opening the file while you're doing a quick read.
Yeah, Mr. Boswick right there.
Mhm. So Mr. Boswick has been on parole since 2020, November of 2020. We have no violations. We have no action in his folder since that date. So nothing has come back to the board's attention. DOC will not recommend anyone for early discharge as a sex offender. I think that's based on the
Yeah.
act from 2008, 2009, back when that horrible case happened.
And his max date is,
I will tell you in just a second. Waiting for this to open up.
It says 6 months, so probably
I
January,
think it's
February.
November. This letter is old.
Oh, yeah. Oh, yeah, it's March. So it's gotta be coming right up.
Yeah.
I still think he's a decent amount of time away. December 9th of 2026. So he wrote prior to 6 months.
Yeah, it's normal hearing info somewhere.
I have it right here. What would you like me to pull out of it? And also get more current info too, if you want more current info.
It's not in the folder of the minimum hearing.
No, I did not pull his offender file. I have it in our parole files, but I did not pull it. I can tell you,
Registers.
That's his criminal history.
yep, second.
What struck me is he went to Windsor. I'm thinking, whoa.
So he currently scores low on the sex offender, looks like the tips, he classified, he's low. It was last done on July. It was last done yesterday.
Wow.
It looks like they've been updating it regularly, like they should every 6 months, and he's been low all along.
Any polygraph requirements?
Let's see. I leave that information out, then we have to come out at a hearing. Cause I don't even think the PO would give us that.
Was there any victim information from the parole hearing?
All we have is a summary, so I'm gonna, without listening to the whole hearing, I'm gonna say we don't have that probably. He's now supervised by Hartford PMP, so he's no longer in the Barry area. At the time he was paroled, he was on furlough supervision, and they case staffed him in October 2020 to recommend him to go before you all. At that time, he had no graduated sanctions in his file. He completed sex offender treatment in the community. He's done everything he needed to while holding a job. Purchased a home and is now a landlord. He follows the rules of his conditions and always calls to ask for permission. That was when he was paroled.
The offense was 2012, so 14 years ago.
He hasn't had any sanctions since 2018. So it's 8 years.
On draft in 20.
Any thoughts, Katie or Tom, on whether we should schedule a hearing?
If it wasn't for his charge, we would schedule a hearing.
Right,
Yes,
That's
exactly.
the issue. Now, the issue would be if it, say he comes before the board and it is, he is, basically forgiven all the time, that will go to the governor's office too, that we paroled a sex offender. However, on the other hand is he's done everything he's supposed to be doing. He had a place to live. He did his treatment at Windsor, which has been closed for forever. I mean, it's a slippery slope. I don't know, but
He's not, it's not gonna go to the governor's office, say he got paroled, because he's already paroled. He's been.
no, I mean about that his
Yeah.
parole was forgiven, is what I'm saying. Because corrections will not certainly recommend him.
Right. That's what my question was gonna be. What if, because I think, Tom, you're exactly right. If it wasn't for his charge, he would be in front of us. So
Yeah.
what is the potential issues involved if
Feedback.
we do schedule it?
Well, it's gonna require, if we do schedule it, that we dig into the case a little bit and majority would have to agree to grant early discharge.
No, I mean, like, what could the potential fallout be if we do
The
grant?
fallout would be huge if something happened.
Right.
Is Tom correct? Do you think it would go to the governor's office?
I don't know what DOC decide, how DOC decides what to put in their governor's report every week.
I guess my thinking is I wouldn't want to make a decision to hear it or
true.
not hear it because I'm worried about politics of it.
I'm
Yeah,
not worried
no,
about the
that's true.
politics. I
Stands
just
on
want
its
people
merits.
to be
Yeah,
aware of be aware of what the fallout could be from that. I don't care about that part
Yeah.
either. But I do
Yeah.
think we need to be aware of what our actions and
of
how
course.
this happened.
Yeah,
And once we do, if say for this case, to my knowledge, have we ever forgiven parole for a sex offender in the past?
I don't know that we've ever had a request to look at one.
I think we've had somebody ask us, a PO asked, but I don't think we've ever gotten one in because DOC won't put them in.
I'll make a motion that we see him.
Okay.
I wouldn't say put him in August because maybe we need more time to research it, maybe September,
Research what?
his whole background and give see time for all of their input.
DOC agreeing to provide any report, any input that they would want. I don't know what research we're gonna do.
We're gonna read the case basically.
Yeah,
Okay.
Yeah.
I didn't know if you'd want
Whoever's one,
less time in between.
Yeah.
December and,
I mean, DOC may push back and want 30 days in case they wanna notify any victims, so I would say September.
we may ask if they haven't.
Right, so September might be,
that's what I was thinking.
yeah,
Give everybody time to
get that clear.
do whatever.
Yeah.
What they're saying? And
Toggling.
toggling.
It's ugly.
And
Maybe it's not gonna hurt to see him.
I agree with Pat, because if it wasn't for the politics, we would.
I mean, I guess we're not making the decision today, so we're just seeing him.
To see him.
I can get on board.
Why should he be different than anyone else?
the nature of the offense.
He has the events.
I will put that that you all have seen murderers before.
Yes.
Yeah. You know.
Katie, Tom, do you want to schedule it? Go from there?
Yeah,
Sure, but the
I
answer,
agree.
MJ's thing about murderers, they usually only do it once.
No,
So,
Well.
no, I have no
hopefully
problem
that's the
seeing him.
case
and
here, too.
it will be interesting to see what develops, but yes.
yeah, I agree.
He was convicted in 2012 and released in 2014. So,
On parole?
I think he was, so originally he had a split to serve case and then I think he violated his probation. And then had his probation revoked and I think
That's
that's
what,
what,
interesting to read case.
Yes,
files.
yeah.
It doesn't sound like
Yes,
it's as
yeah.
serious a.
yeah.
That's what I'm thinking.
He had his probation revoked on January 23rd of 2015. And that's when he received,
Or
I don't know all the details of the violation.
14 and 18, he ended up with a few sanctions and ended up on furlough and did a better job than he did on probation.
so he was given a probation sentence.
So he was originally, hold on.
Yeah.
He was originally given a 3 to 15 year all suspended, but and he had to serve some. Then he had his probation revoked on January 23rd of 2015 to serve the 3 to 15 years. And that's currently what he's serving.
Okay. So we want to find out what that was.
So since January of 2015, so he's been serving the sentence since January of 2015, the full sentence.
So he's at 11 years.
Yeah.
Yeah.
Sam, and toggle, if you're okay.
Yeah, I can get on board.
Okay. So I guess we are unanimous in scheduling a hearing.
Okay.
Go from there.
And I apologize for throwing these out at you without a whole lot, but I figured we could at least have some initial discussions about how you wanted, if you wanted to schedule or if you wanted more information beforehand. And I have one
All
more.
right, well,
This one's 4 pages.
It's another case.
Oh, it's a handwritten one.
Yes.
Very good.
I didn't give you the reconsideration that. I didn't give you the reconsideration that's got highlighted red and yellow and all kinds of crazy stuff in it.
Reconsideration.
Yeah, that one I haven't got to. And that one I want to do some digging before I bring it to you all. Sometimes the reconsiderations really aren't reconsiderations. Looks like he is serving a sentence for unlawful restraint, 2nd degree, burglary occupied, aggravated assault, and careless and negligent driving.
That was enough.
He cannot travel to Rutland County or Burlington or Shelburne.
Look at it where you go.
Yeah, this is one I'd probably have to recruit myself. I'm very familiar with the case.
Yeah.
He maxes out in February of 2027. So if we wanted to postpone this one to get information from the PO, that would be fine too, because this one is a listed,
Yeah.
and I didn't even actually look at the date of when he was put on parole, so he may not even be eligible. I apologize.
Mm,
He convicted of,
Those were what he was convicted of, what I just read. Aggravated assault, unlawful restraint, 2, burglary occupied, and there was one more.
Breaking around
It was
houses.
alleged was sexual assault.
Careless and negligent driving, those are his 4 convictions. What he's currently serving for.
So his max out day is February 2nd, 27.
It's sober since.
Yeah.
Oh.
And this happened in 93. So it sounds like he hasn't.
He's been on parole since January of 2014.
Wow.
Yes, he is he more than meets the criteria
Yeah.
of. Oh, wait a minute. Oh, there we go.
He revoked his parole.
Back in 2011. He was granted parole in September of 1999 and then revoked in September of 2011. Yeah, he's been a very. And I don't really want to post it all on the board because we're recording.
Right.
73, 74 years old.
Like he picks up a new, that I think is, so I think what happened is I'll look at his violation. I think he was revoked due to the new careless and negligent driving.
We have someone pretty much fall into the 6 months thing. We Get some information from.
Yeah, it'd be a listed that we
Yeah.
review, yeah.
Yeah.
Wouldn't be a 6-month one, but yeah. Looks like he had some issues with a residence and
Mhm.
at the time his parole was revoked as well.
Then he got married.
And until then, he was on parole from 1999 until 2011.
Hmm.
So he was on parole for 12 years
And then he picked up the
and
CNN?
some other stuff too, where I guess he had a restraining order on him from somebody.
wow.
Just interesting how he goes those long periods of time.
Yeah.
So it makes you wonder,
Is he doomed?
is he done or is he?
Yeah. Is he gearing up?
I don't know. I'm just looking at the pattern.
I'm toggling on this one.
Well, potentially a 6-month.
Yeah.
So
Yeah.
DOC,
Oh, yeah, 'cause it is February.
Yeah.
I'm thinking we are going, never mind.
yeah, it's okay.
We're going into 2020. Trying to go backwards.
So thanks now.
Anyways.
Wasn't worse.
Guess it wouldn't hurt to see him then.
Yeah, I guess him and his girlfriend had broken up.
He went into a depression.
No, he was delaying moving out of the house, and she had told her that she'd have to get a restraining order on
What
him.
year was that?
That's a violation in 2011.
Okay.
And then he'd been driving. And the driving piece.
Didn't say any alcohol was involved with the driving thing.
But it sounds like it was all due to his feelings of rejection and abandonment.
He said he tried to commit suicide in his letter, so I wonder if that's what it was too.
Then right here, he actually did a welfare check on him in September 2011. Because his sister called and said he was planning to shoot himself.
So, any other thoughts?
See him.
Katie?
Like I said, I'd be a no.
I mean, I think we need to I would like to hear definitely what it's been like on what the PO's input is, for sure.
Yeah. Which we would get in this case.
Yeah.
So Tom, are you recusing yourself on this one or just say no?
I'd recuse myself on this one. Yeah, I know too much.
Okay, good idea.
Yeah.
That's easy enough. When you know too much, it's a good idea to back out.
Yeah.
I still leave 6. We still got a quorum.
Yeah. Anyone else have any thoughts?
Oh,
Okay.
nothing.
Sam?
I'm on board with saying that.
Anyone?
So Tom, if we subpoena you to this hearing, are you gonna be?
I would love to be subpoenaed, but go ahead.
Yeah. Hostile witness.
Yep.
We treat them as like us.
Okay. All set on list 2. Let's talk about affirmative defense.
So I want to talk about affirmative defense without getting too deep, because we do have an active case right now.
MJ, before you start, I have to go to take care
Okay.
of that. I hope to be back soon if everything goes well, so,
Okay, good.
That's all.
okay. See you guys.
We'll be here.
We'll wait for you, Tom.
Yeah. We won't go anywhere.
He has a screen to himself.
All right, so recently, this has happened in the past and it's come up again, lately around, affirmative defenses around basically stating I was forced to do, I was forced to commit these acts.
Devil made me do it.
There you go. I was forced to make these acts for fear of my life, or I was being trafficked, or I was being so forth. So I just wanted to just give, I'm gonna reach out to our attorneys just to get a little bit more information on it and how to proceed with these. I just didn't have a chance because we do have an active case. I don't want to get into the details of that active case.
Right.
But I just wanted to give folks just a heads up that it's circulating.
But if someone is using affirmative action as a defense, then essentially we have to determine whether that is credible or not.
Right, and the standard, and I looked up the standard and the standards preponderance.
That's for the court too.
Yes, to determine if it's an affirmative defense or not, if they were forced to.
So
Did
basically,
you find something differently?
I found that preponderance too.
Yeah. Well, he was doing his facial stuff.
Yeah, I heard him.
It's- If the court has decided,
Right,
we're not gonna decide differently.
right,
Right.
exactly.
That's, my point was going to be, until the court has made the decision, if it's going to the court, the problem is going to be if it's a violation where the court's not involved. It's a program, then
Like it's a,
I think that's going to be more often than not.
right.
I agree.
Like with I absconded and didn't report to my TL, it was because I was being held captive or.
Yeah.
So I just wanted to throw it out there just to let folks know that it's circulating again.
There are steps. Even if court didn't find that, there are steps that the victim that I'm quoting here
Mhm.
should be following to go through to document the affirmative defense.
And also, another thing too is that they may, with this affirmative defense, it may come down to the individual and the attorney may want an executive session to talk about this private information because they are in that much of a fear. So just another warning as well. So just,
Should probably be research.
Which is fine. You know, in that case, we certainly don't want to jeopardize
right,
the person and we need to go into a deliberative session.
yeah, and we just have to be very careful that the information that happens in that session is strictly around that and not any board business or anything to that degree. And that's where it gets hard, and it gets hard with the documenting of the cases. Like with this ongoing case we have right now, the same board is following this case because we have no record of that executive session other than what the board has documented in their notes.
But this is clearly one where the court is taking an action.
Yes, the court is involved in this one. So I just wanted to just put it out there just to let folks know that it's circulating again and I'm planning on getting more information from our legal counsel on this too.
Any thoughts or questions? I think the key thing is the offender is essentially admitting violation, explaining the extenuating circumstances through affirmative action, and then for us to decide whether that is a legitimate affirmative action by a preponderance of whatever evidence we have.
And if you do determine that is the affirmative defense, that the affirmative defense is legit, then they would not be found in violation of those
Right.
provisions. So I just wanted to be clear that even though in essence they are admitting to it, but because they were under duress.
Yep.
They are not, we wouldn't find them in violation. So it gets confusing.
And then the other potential is that, say they were charged with violating 6 conditions and only 3 of them really apply to the affirmative defense.
Right.
What do you do with the other 3?
Right.
I guess it depends on what they are,
Exactly.
you know.
Yeah.
They don't have
Are they
anything
indirectly
to do.
related?
Yeah. You could find him guilty on those.
Work from Pat, Wayne and Tom on how this one goes.
When it
Goes.
when it goes.
Here.
Hopefully we will settle it in a few weeks.
Yes. Okay, anything else on that?
No.
Okay, Katie, you all set? Update our ICOTS rules.
So I wanted just to bring to everyone's attention, we just had a very unique case, and I learned that the ICOS rules have recently changed. So I thought it would be helpful to bring it to all of you. Also, Emily Wines has found some new videos on the ICOS website. I'm gonna look at them and vet them and determine if I'm gonna send them out to all of you. But so what was really unique and helpful is recently we had a case where this individual was met. We ICOT'd them to Ohio. While in Ohio, he committed a new crime. He was sentenced in Ohio to serve a certain amount of time. And then he had some supervised release on parole conditions. The parole board didn't actually see him, but he had from 1 year to 3 years that he had to be under supervision in Ohio. He had no connection to Vermont other than that one crime he committed, then his Vermont crimes that he committed while he was here as a contractor. So with the new change in the law, we didn't have to extradite him. We could choose, if we thought it was going to be in his best interest to stay in Ohio, to have his parole violation hearing remotely, adjudicate the violation, and if we continued him on parole, then they could reapply to ICOTS and he could stay in Ohio. So instead of us extraditing to potentially continue him on parole, to then send him back to Ohio,
Where he's on parole in Ohio.
which has been happening a lot. This is, I guess, have been happening a lot throughout the country. So the ICOTS had changed their rules because previously we had to retake.
Right. Mandatory retake.
Yep, and we'd have to bring them back. We would have to pay the extradition, bring them back, look at the totality, the hold our violation, and then there was many we were sending right back to the other state.
So he was a resident of Ohio to begin with, came to Vermont, committed an offense. We ICOT'd him back to Ohio. He committed an offense and was on parole there.
Yes.
Well, he's not on parole yet. He will be on parole next. Yeah, he'll be on parole in 2 weeks.
Interesting.
Yeah.
I mean, no, not 2 weeks. Next week, Sunday, I think is
Wow.
release day.
They can have it.
Double.
They got it?
Yeah.
Well, so what happened is we held the violation hearing. We continued him on parole. We're reapplying for ICOTS.
Well, he's there.
While he's there, he's going to go out on supervision for at least a year, maybe up to 3. And if he does something well during that period, Ohio's going to reincarcerate him. His supervision time is most likely going to be longer than what our supervision time is going to be.
What's his max for us?
Early 2028, if I remember correctly.
Good case. He had a lot of support too.
Yeah, I had a lot of
Really?
support.
Yeah.
There was a lot. It was a good test case.
He did a lot while he was incarcerated.
And he cried for us and everything.
Did he do a lot of?
They had a lot.
This is what I did not pick.
They had a lot of programming.
In Ohio?
Yeah.
In Ohio.
Yeah, they
And
did.
it was interesting too, because working with that facility was so much easier than working with our own, because it was a CoreCivic facility. So Ohio contracts with CoreCivic in their own states. And we can't even get our vendors on video that are in a CoreCivic facility in
Was
Mississippi.
it a fraud case for us? You said he was in construction.
I don't know what it was.
Okay,
He
I
was,
wondered
he
what,
was a
what his offense was
I think
here.
it was domestic stuff, but I don't
Okay.
remember.
And
But
that's what it was there.
In Iowa, yeah.
Okay.
I don't remember what it was. He was traveling for work, so
Oh.
he was a contractor of some sort. So he was
I was
traveling.
wondering if it was a fraud thing.
No, I don't think so. I don't remember all the details.
Hmm.
You just love all the details of every case, don't you, Pat?
I do.
Good you remember those.
I do like details.
So,
They refer to it as ICASA report.
ICASA.
Is that a typo?
no, so now it's the two, so there's
I can see interstate compact on, what's the essay?
so it's the interstate compact of, hold on.
I just wonder if there's a whole new compact aside from ICASA.
No, so it's interstate compact for adult offender supervision is really what it is. We just call it ICOTS, but their technical name is Interstate Commission. It is actually Interstate Commission for Adult Offender Supervision. So when you open up their computer system and all the reports that you get, it will have ICAOS at the top of the reports.
So even though in the report from Ohio, which said mandatory retaking, the rules changed, so we didn't have
Yes,
to.
the rules changed since then. And also, they are also rolling out a new system for the interstate, interstate compact as well. So the reports are gonna be changing too. I don't know exactly when that system's going live, but once I find out more, I'm gonna try to attend one of the info sessions that Rick Plank is putting on. To get more information. So the reports may change, but even though it said mandatory retaking at that point, I think that rule just changed within the last year.
In this case, that's good.
In some cases, it is good, and it saves us a lot of extradition funds.
First, just send them back.
Anything else on that?
No,
Joe? So let's start off with Angela. What's going on?
We had a couple of cases last week where the Parole summaries were not the same. Like Pat and I had one that wasn't the same as, I think maybe Kate.
are you talking about the disciplinary reports?
Yeah, they were different, and I was just wondering if that's something we have to keep in.
So I can hop on that one. So that was actually one of my roundtable items, but that's okay. So
Nice blend.
we had an anomaly last week, where the parole summary was populating the, infraction history or the infraction information for a different offender, a different inmate. So what happened is there was an incident that involved two offenders. The parole summary was pulling, and because they call them subjects in the system. So because two individuals were attached to that one incident report, it was pulling the infraction history, whether they pled guilty or not, to the VR for the wrong offender.
Yeah.
So this guy was not guilty of these. He pled and was found not guilty of these. And in fact, the parole summary was showing he was guilty
Yes.
because it was pulling the information from the other person. That has been since corrected.
Okay.
I put in an IT ticket to the offender management system team. They have corrected that.
How was it learned in the hearing?
We
Because-
questioned it.
Caseworker said he's been doing really well in the
Yeah.
facility, and I said, our report has two
Yeah.
DRs in June and July.
Yeah.
And he said no. And I said, that's what this says.
Yeah.
A lot of that.
Yeah.
So, and do you mind if I take a little bit more of your time to hitch on to the VR wagon? Because it goes even further. That same hearing day, we had another one where the individual had committed 2 DRs this month that were not on the report because the report was submitted prior to this month.
Right.
So I'm going to go into the LUS and supervisors meeting next week and say, your caseworkers and POs need to be ready to present any DR history since the date the report was written. So I would also encourage all of you in your questioning around that, point blank say,
Yeah.
clearly, has there been any DRs since the report was written? And just be clear, because I feel like we have to simplify a lot of these questions down lately.
A lot of times what's listed in the report is dated. It
Yeah.
could be 2 or 3
Right.
years.
So
Yes.
I just wanna throw that out there, because that one case had, because Pat's like, I don't have any of that. The last one was last year for not doing hygiene. I can't dig in for not doing hygiene.
Yes.
And then I looked and I'm like, but he's had a major and a minor since July 1st.
Yeah.
So just another anomaly that we
Yeah.
had, but I think it's probably happening more often or not that they're submitting the report so early
And
sometimes.
not
So
update.
just automatically question what's the
Yeah.
history.
Yeah.
And we never used to, because we would just take it as gospel. Then I look at the case staffing. And I read the dates on there.
I would also encourage you to, if the infraction report is attached to the end.
Yeah.
I would encourage you to rely on the infraction report before you rely on the information in the summary for the narrative,
Yeah.
but rely on the infraction report for the actual guilty or not
If
guilty,
it's there.
if it's there.
Yeah.
Just to throw it out there.
I love having the case staffing. Oh,
Sorry, Angela, I kind of took over.
No, that's great. No, yeah. So like, what's going on with those floors? Gonna be a common thing or? Okay, no, that's good to know. My other question is, which is just my personal system, to get the SDMF forms in our folder so I can just immediately save
I
it.
could put in a ticket for that and I will get that ticket put in.
Because it's
To do what, Tom?
because I have to,
Being to the folder.
yeah, I can't save it. So I have to download it and then re-save it and then re-upload it.
Keep going to put a ticket
Yeah.
and then I keep getting.
Is it just
Especially when there's like
Yeah.
10 a day, it's like
Yeah.
15 minutes of just
Yeah.
downloading
them and
re-saving
Wow.
them. And I miss them sometimes though.
yeah.
Did you ever figure out what happened with her compensation?
Yes, they had her set as net 30 instead of immediate payments. They didn't check it after the fiscal year rolled.
Yeah, that's why I was like, I'm pretty sure the state's just screwing something up here because
hoping
it's
you-
the state.
You got it now.
I haven't looked, yeah.
The July 1st screws everything
It
up.
does. New fiscal year, no money left.
Yeah.
Yeah.
Oh, no, we have plenty.
Yeah,
Luckily.
Thank you.
thanks. Katie?
So I think things are going, I'm just finding it, I think the more and more my full-time job is picked up with clients, I'm just finding more and more conflicts, which is frustrating. But that's just a me thing. But I'm also finding super frustrating that kind of like what Angela touched on is the parole reports are done sometimes like months because they put them in they do the parole summary and then we may have to postpone it or something happens, but they don't go in and update it. So what we're getting for the parole summaries are like sometimes months behind what's actually occurring. So that I'm finding super frustrating. I think the other thing for sure is it seems like everything is coming back not recommended and it's not matching up with what oftentimes what the either the caseworker at the facility is saying or what the parole officer is saying. So that to me is frustrating because it's like
Yeah.
I get torn between what is that going to look like if we want to actually parole them. And then also their release planning isn't done. They're doing it on their own, but we don't have anything to back up what they're saying is actually accurate. And that's super frustrating because even if we want to, we don't have that proof from DOC that says, yes, he could go there, or yes, he is going to be enrolled in these services if released. So that's just kind of what I've been noticing over the last month, for sure, last couple of months.
Part of what it comes down to too, Katie, is that if we're not sure, but we like what's being presented, we can say that it does need to occur. This has to happen, or they're released, or the residents must be approved, and that whole thing.
Yeah. I would like to be also, the other thing I was thinking of too, I don't know if this is a new program or I noticed in some hearings over the last few weeks, we've been hearing more about this program where I forgot the name of it, where offenders are actually being like mentors. Does anyone remember the name of that?
Yes, yeah, yeah.
Here,
Drop in or something like that. What was it?
I bet you it may, yeah, I'll find out more.
Yeah.
It came up in I know one in particular, it came up in the Rutland, in the Marble Valley Day. It came up in a couple of hearings, but I remember one was being a Marble Valley Day where they had, then I forgot the name of the program, but I would love to hear more about it. If it's new, sort of what's, because I hadn't heard of that before, that hadn't come up before. So I would love to, like, how are they choosing the inmates that are doing the substance use mentoring, and how often are they meeting, and what's the criteria for it? And I would just like to hear more about it.
Yeah.
Sometimes it creates a little bit more of a like a conflict for me, because like, for instance, this last one, the person that was actually doing the peer mentoring and wrote a statement of support was actually someone that I knew from somewhere else. So, but I had never heard of the program, so I didn't know. Has that been around?
He was taking a leadership role
Yeah.
while he was incarcerated.
That was one case,
Leadership
and then there
role.
was another one. Yes, so that we had heard about it there, where
Mhm.
he was actually doing it. He was enrolled in the program as a mentor. We had one case,
Right.
but then we had another case where someone was enrolled in the program and they had a mentor, and the mentor wrote a letter of support from that program. So,
So what?
is it new? Am I wrong?
I
No.
don't know.
I remember seeing it too in the report, and I've seen it a
Maybe I
couple
can
times
go
now.
in and look, because
So what my goal is, one, to have the risk intervention services come to a future board meeting. I haven't got them looped in. I want to have them come. I also now want to get restorative justice here with all of their programs that we just found out more, which that one may be part of it, Katie, that you're talking about.
open ears. Sorry,
Open
open
Oh,
ears.
Open Ears has been around for a long time.
Yes, that was it.
That has been around for a long time,
We
and
just
so
didn't hear
maybe,
about it.
That's the first time I heard about it, was this last
well,
one.
I think,
Yeah.
so,
Sorry,
I
MJ, to
will-
cut you off. I apologize.
no, it's okay. So I'll try to get DOC to come over and talk about all these programs, from risk intervention services to Open Ears to restorative justice, and go from there.
I wonder if it's something that they're starting to utilize more in the
I don't
facility.
know.
And that's why
I don't know, but I
all of a
don't want to
sudden
go down
hearing-
this rabbit hole right now.
No, it's okay.
We're already
It's
supposed to be
okay.
doing SDMF.
Sorry.
No, it's
No.
okay. I just don't want to go too far into the weeds when we don't have all the information.
Yeah.
Because we
Exactly.
can go as far, we can start digging, but we're just guessing at this point.
That's true.
Thanks, Katie. Anything else?
No, that's the only things that came up for me this month.
Well, I guess I had asked earlier about the form, the SDMF thing that we did, but MJ solved that little problem.
Well, I didn't solve it. I just
No,
told
but-
you to wait till the SDMF part to talk about SDMF.
I just,
You have to lay.
yes, I just lumped the information that we got in the different descriptions of the domains and what's, what we could consider and what their rules are. And it's just, it went into more depth than what we've got. So,
It conflicted with a lot
Yeah.
yeah,
of stuff that we've
But I-
been doing.
yes, yeah, it sort of changes your thought process.
Can we not go too far into this right now?
Okay,
This is
yep.
for SDMF.
Okay, I am moving, the 17th. And I've got to somehow get the internet in. There's internet there, but it's not private. So I'm gonna get my own internet.
Mhm.
And hopefully they can have it in by the time that week rolls around.
What do they have, do you know?
I don't. I just know it's free internet.
Yeah.
But it's public and I don't want a public internet. So I'm gonna get my own. I think they said it's $30 a month for me to get my own internet. Yeah, that's what I figured. So
Yeah.
I've got to go to, I don't know.
You don't know who the provider is.
Xfinity maybe.
Mhm. Good.
Yeah,
Yes, yeah.
yeah. I think that's what it is. But the woman's on vacation this week, so I can't ask her until next week. So
Mhm.
hopefully I'll be up and running.
Yes.
Multi-tier.
You there.
We're gonna SDMF.
Well,
We're gonna
4 or
SDMF.
5 years ago, it's like a constitutional amendment. And we got back to where I thought we ought to be, but now I'm just wondering if we couldn't just correct the English in condition number 1. Take out 2 words. Instead of you shall not commit any act punishable. Let's do
Any act?
correct English, you shall commit no act punishable. Just simple English, the correct English. And every time I read it, I just. And I asked an English major the other day, she goes, oh yeah, you're absolutely right. That's it. That's the only be in my body.
It's easy for us. But it's not gonna be easy in the realm of things now that all of our reports are tied to DOC. We went down this road with taking work out of condition 16.
So as we read that condition, I'll try to remember to say it that way.
Yes. And so what I would like to do, so at this point, what I would like to, I will make a note of this. At some point, we're gonna have to figure out, and I know I was waiting for a new chair to come on too, because I hate to change everything, have a new chair come on with a new philosophy. And then start tearing everything all up with you all again. Because you never know. I hate to say it, but I don't know what we're gonna get.
You can mold them.
know, I've given my input a bunch of times and
We just don't know. But
we just don't know.
that's it, Wayne. That's all you got.
That's it.
2 words.
I just think that we see a lot of complex cases and it's just a good reminder that we have a hard job, but we're doing a good job at it.
I agree. Thank you.
And we undercompensated for it.
Absolutely.
100%. I wasn't gonna go there, but you said it.
The legislature started to go there last.
Can I
Oh,
forgot.
you've already had your thing.
I forgot,
We'll do overs.
we had a couple of hearings where the victims were not notified, and needed to be. Just so you guys pay a little attention to that. See it, because then, we had to postpone the hearing, because I asked MJ about it, because the victims weren't notified.
And so, and also just to hit on that, I think it depends on the nature of the case too, and the nature of
Yeah.
the totality of should the victims been notified? Should the victims, because we've had board members that are very extremely, that even if it was the littlest convenient, this big, huge convenience store company needed to be notified. So it's really the judgment of the board to
Yeah.
determine if it should be
Yeah.
postponed or not, and use your judgment when you're making those determinations. I would highly recommend that not every case probably rises to that standard.
That's one of the things too, for me, it's helpful because I do the SPMF as I'm reviewing the case. I get down the victim thing and I look for the notification. What was the victim impact in this case? And then make a note whether or not we should follow up on that.
And that's something I need to also follow victim services, because they were talking about getting rid of the victim notification form. So I gotta follow up that.
Why?
When we had.
I don't know.
Manslaughter. I found it remarkable that they could not locate three, obviously not victims, but witnesses, since our family members with us. Like, oh,
Anything else, Sandra?
Opportunities.
Samuel, so a couple of quick things. One was, recently it seems to be a lot more prevalent than in the past, where we're getting substitutes, particularly in the jails for casework. I have no clue about the case.
Yep, that is another
And yeah, the most recent one that was frustrating, and I think you
northern last week,
were last
both
week.
days.
I'm talking to him as he's walking away.
Yep, they're walking away.
That's what I was just gonna say. They literally walked away. They gave a quick
Yeah.
report and walked away.
And had no knowledge of what was going on there, which is frustrating.
see, I wasn't gonna throw stones, but yeah, I mean. We've had, in the last month and a half, well, someone's was on here, I'm just covering, I have no idea what this is,
Yeah.
and read it, or. Both of them are subbing, case staff and parole officers. And they're talking about a totally different person than what we've got in front of us. People read it.
And I can give a little sympathy to Northern, who's extremely understaffed, so a lot of their caseworkers are doing security staff. I totally get that, but if you're not prepared, then you need to tell us.
Yeah.
And I can understand a supervisor feeling. Sometimes the POs have had their supervisors filling in, and I think they've actually done a better job than
You're
some
right.
POs.
Yes. No,
So-
and most of the POs that sit in are really good.
And I will say Burlington is switching over their reentry POs right now. Because one of their reentry POs was, promoted to supervisor, so I think we're gonna see a little bit of different faces in front of us. I think Alex Fontaine has now got the reentry caseload in Burlington,
Oh, really?
along with Michelle Ksenia, so I think that'll be good.
That's good.
So, I think Alex took the caseload over from Jake, because Jake got promoted.
I like Alex.
The other thing is on violations. I know we're kind of still morphing into what our role is going to be on that. And where we've had witnesses come in to direct questions towards the evidence. And typically we have been sitting back and letting the evidence be presented to us. But the only thing I would encourage is if any of you have any questions about any of the evidence as we're evaluating it, don't hesitate to let me know you have a question about it. You either need to clarify it or you need to pursue it a little further or whatever. In the past, just leaving it and we make our decisions on what's presented. We can't do that. We've got to dig in a little more.
Really? Why the change?
Pardon me?
Why the change from the change?
I know we discussed this months ago, that we could dig in a little bit more.
Well, I'm just saying we need to.
Yeah, and I think we had discussed this a few months ago when we started going this way.
Good. Anything else?
A few things. The first thing is I have had a conversation with the Criminal Justice Institute. They have received some grant funding to work with parole boards and DOCs to improve their communication. where they, if the state is picked, they would come in and kind of mediate to look at is DOC and the parole board sharing the correct information? Is the parole board getting the information that they need? Is the communication going well? Kind of to help us, because there's a lot of information that we don't get that we should be getting, like programming information and so forth. So I thought this is a good opportunity that if we can get somebody to come in and kind of lead those discussions between the two entities. Because we're not, I think we're stonewalling each other a lot. And I think having somebody come in and be able to lead that, it might be helpful to get the information that you need to make the decisions. Like they keep saying, well, you're overturning our RSM.
Yeah.
Well, like I mentioned earlier, I feel like we're not getting the information, the complete story of why and what information is missing. So I saw this as an opportunity to put our names in. And I haven't heard back, but I thought, why not take an opportunity to have somebody come in? I have support of DOC's on board, the governor's office is on board, AHS is on board. They all thought this was a good idea as well.
So this is CJI?
Yeah, so CJI, so Abigail Strait, we had worked with her a little bit back with the SCMF. She worked for CJI. She's not there anymore. I've been working with a lady named Valerie Mead. And so I've met Valerie many times at APAI stuff. But I thought it was it's an opportunity to come in to have somebody who can lead the discussions, where I think sometimes we get stuck in how do we navigate through this. So I wanted to throw that out there. I went to New Hampshire at the end of June 30th last month. I don't even think I've wrapped up you with this, Dean. I thought it was interesting how they do some of their processes. With parole hearings, they don't interview the caseworker or the PO. They just interview the individual because they get a more comprehensive packet. And they don't have the case presented by DOC. They just get the report that details everything. And as they're rolling out SCMF, they're starting to do some of that, really looking at the report to see how it meets. Also with violations, I found it very interesting with violations, that they don't read the individual conditions. They will face the individual's attorney and say, well, are you going to speak on behalf of your client? And if they say yes, then they will say, are you waiving the reading of the allegations? And in every case I watched, they waived them. And then the attorney would say if they admitted all or which ones they denied. It was true or untrue in New Hampshire.
Yeah.
But I thought it sped it up a little bit. And made the attorney work with the individual ahead of time to know what it was, because we've had that happen once in a while with attorneys, and it makes it a lot quicker.
Yeah.
So we don't need to go
When
through
the attorney
reading.
steps up to say that, I always let him say, yeah.
So they just go ahead and do that, and then the POs in New Hampshire don't have an attorney with them, but they do everything that we were doing before. They would question the individuals. They would provide all the evidence that they had. The attorney would question them at times and so forth, kind of like what we would see normally here. The DOC is now pushing back on. So I just thought I'd give you that little.
Going back to the interview of the inmate, if the PO's not there, what if you had a clarifying question?
I don't know if they worked that out ahead of time. I don't know.
Okay, that would be my concern. So if the inmate is saying, if the offender is saying something different than what you've got, like programming or whatever, how do you decide which one is?
They also didn't dig in. It didn't seem like they were digging into the cases quite as far.
I want to know if the PO is refuting something.
Yes, yeah.
So I think it's just a different thing. It'll be interesting once I bring SCMF on.
Yeah.
CFH.
Change it.
I just thought I,
But in the violation hearings, we could certainly begin by asking the person's rights attorney. There are 4 conditions of your parole agreement you've been charged with violating. Are there any that you admit to at this point? Or deny, and let the attorney tell
Let
us.
the attorney take the lead on that.
yeah. I don't know if we want to have that conversation with PRA. Because I know the individuals get awfully confused sometimes when you read those conditions and they don't know what you're talking about. So
And they stop and they'll say, can I talk to my attorney?
You start doing that, okay. You're gonna have that every time.
Yeah.
If you start using that question, unless PRO's already come to town on this,
Yeah,
I need to talk to my client.
Yeah.
So we're gonna sit there and huddle our thumbs for 20
Well-
minutes.
or I can ask the attorney, have you had a chance to talk with your,
well,
about the conditions? Are there any that they admit to at this point?
well, and I don't think it's a matter. We shouldn't. So I'm gonna be blunt. We shouldn't have to say that.
Say what?
They should be talking to their client before they're coming to the violation. Yeah.
They don't, because they see this opportunity to.
Yeah.
Call any of them out,
No.
but some are better than others.
I like that.
So it's just an idea of, as we're going through that, it could save a substantial
Yeah.
amount of time, especially if there's,
Works for me.
What's his name? The only one ever talks to his clients before hearings. He's great.
I like Emily does too.
Yeah, Emily's great.
It's Jill.
And then there's the J word.
Anything else?
All right. There's nothing else.
We will adjourn board business.
I'll make a motion that we adjourn. Or part of this,
All right.
And she'll reconvene at 1 PM.
reconvene at 1 p.m.
Second.
By Wayne, all in favor, signify by saying aye.
Uh,